This is Bloomberg Law with June Grasso from Bloomberg Radio.
And his face lost all expression. Said if you're gonna play the game, boy, you gotta learn to play it right. You got to know when to hold 'em, know when to fold 'em, know when to walk away, and know when to run.
Superstar Supreme Court lawyer Tom Goldstein took the stand at his criminal tax trial, going all in with extraordinarily high stakes, even higher than those at the multi-million-dollar poker games he played in. And gambling is at the center of the trial, where Goldstein is accused of misreporting millions of dollars in poker wins. He lived a double life as a member of the elite Supreme Court bar who argued more than 40 cases before the High Court, and as a high-stakes poker player who won about $26 million in one series of matches and once walked through U.S. Customs carrying a bag of nearly $1 million in cash. Goldstein knows the odds and risks of taking the stand and opening himself up to cross-examination. But he's gambling that the jury will believe him and acquit him. Joining me is Bloomberg Law senior reporter Holly Barker, who's covering the Goldstein trial. Holly, start by telling us about how shocked the legal world was when Goldstein was indicted.
Tom Goldstein is a legal rock star. He's argued more than 40 cases before the U.S. Supreme Court, and he got there via a really unlikely route. Most people who make it to the Supreme Court, who are that kind of elite lawyer, also went to elite law schools, and they clerked for Supreme Court justices and so on. And he sort of got there through pure hustle. He would identify cases that he thought were likely to get taken up by SCOTUS, and he would cold call the people involved in the case and sort of pitch himself as the best person to take it up. And that's kind of how he built his career. He was also the co-founder of this thing called SCOTUS Blog, which is a website that sort of covers all things Supreme Court and became a really critical resource for people in the legal world. So when he was indicted last year on 22 counts, a combination of tax charges and allegations that he made a false statement in connection with loan applications, people were shocked. Those charges have been winnowed since they initially dropped. He is presently on trial for 1 count of tax evasion for 2016, 8 counts of aiding and assisting in the preparation of false and fraudulent tax returns, 4 counts of willful failure to pay taxes, and 3 counts of making a false statement on a loan application.
How did he get into this world of high-stakes poker, and how much money did he make from playing?
So he'd had an interest in gambling. Like, he would play poker with people in his law firm. You know, he represented people in the poker world. You know, one of his clients is featured heavily in this trial. But it wasn't really until 2016 till he started playing these like massive multi-million-dollar hands. And that's sort of when things surfaced for him. And at trial, since he's taken the stand, it came out that in 2014, he had a pulmonary embolism and almost died. And after that happened, and I'm paraphrasing here, but he sort of felt like, I've got to seize life. And he went on to say, I may have overcooked that a bit, but that's sort of what led to his gambling in his sort of peak year in 2016, although it continued for years after that with him mostly losing. But to answer your question, he played Alec Gores in 2016 and won around $26 million from him in a series of matches, to give you like a rough sense of the kind of dollar figures we're talking about.
The prosecution presented more than a dozen witnesses, from IRS agents and accountants to professional poker players and real estate moguls, and even one movie star, Tobey Maguire. Who were the most important witnesses for the prosecution?
I think the most important witnesses in this trial for the government were likely the accountants at Goldstein's outside accounting firm. His defense, there were errors on his tax returns. He's not disputing that. There were transactions that should have been characterized differently, either should have been characterized as income or shouldn't have been deducted as business expenses. And there's only a handful of them, 8 to be exact. And he's saying, look, yes, those should have been characterized differently, but it wasn't my fault. I was relying on my outside accountants and my firm managers If they had any questions, I would answer them. I would answer them honestly and to the best of my ability. And they were the ones dropping the ball on this. So in that respect, getting the accountants on the stand to sort of explain what their process was and the efforts that they made to get his returns right was really important, I think, for the government. But I will say that the cross-examination of both of the accountants was super effective. They highlighted mistakes that the accountants made that hurt Goldstein that he didn't catch in terms of his tax liabilities. And they didn't follow up and ask specific questions. Goldstein's lead defense lawyer just sort of took it apart.
You know, I have to ask you about Tobey Maguire's testimony. He's known as a high-stakes poker player.
Tobey Maguire is apparently a very avid poker player and also a seemingly very good one. When he stepped off the stand, he left me with the impression that he could have made more money playing poker than he made playing Spider-Man. He took the stand to testify about a $500,000 legal fee that he owed to Goldstein after Goldstein helped Maguire recover significant gambling debt from Andy Beal, who's a billionaire in Texas. So he won $15.6 million in poker. About half of that was his. Beal didn't want to pay, so he hires Goldstein. Goldstein does the job, gets a successful result. Maguire gets paid, and Goldstein has this $500,000 fee. But instead of having Maguire send the fee to him, he had Maguire send the money directly to someone to whom Goldstein owed a gambling debt. So the idea was to have him come in and testify about this transaction that was ultimately misclassified. But again, Goldstein isn't disputing that certain transactions were misclassified. What he's saying is the way that it was classified on my tax return is not my fault. It was an error, but it wasn't an intentional error.
And whether or not he had intent is key in this case. So Goldstein knows his way around a courtroom, obviously, but getting on the stand yourself is another ball game. What was his demeanor like?
He was calm, collected, self-deprecating at times. He seemed very well prepared. He didn't sort of over-explain. He seemed sincere. I think the big risk in a lot of these cases with defendants taking the stand is the risk that they'll come across as arrogant. And he didn't come across as arrogant at all. He did a lot to bolster the defense's themes that they had been teasing out while crossing the government's witnesses. And one of the most important things I think he did on the stand was sort of tie together and fill in the gaps in his gambling. And when it all was said and done, he actually said that he should not have reported any gambling winnings on his 2016 taxes. He said that he, in fact, overpaid, which sort of upsets, obviously, the government's 2016 tax evasion theory altogether.
The risks always come on the cross. Was the government able to score any points on the cross-examination?
So on cross, the government started with sort of establishing that he has free will. Essentially, they were trying to get him to acknowledge that he made all of the choices that led to these mistakes and that he was fully capable, for example, of telling his firm managers about when a distribution was personal and shouldn't have counted as a business expense, but failed to do so. And they sort of framed that as his choice. They then shifted very heavily into his spending and sort of history of being dishonest with various people in his life. One thing that did come out on his cross-examination that I think the defense had been working really hard to avoid was all of these allegations about infidelity. The prosecutor essentially asked, didn't you lie to your wife about your many, many, many affairs? And he avoided answering the question by saying, that would require me to talk about conversations I had with my wife, so effectively invoking marital privilege. And the prosecution moved on. But of course, now that's out there and that, could sully his credibility with jurors a bit, although I'm not sure that infidelity packs the same punch that it did, 30 years ago. But still, of course, that cuts against his credibility. He also acknowledged other sort of misleading things he'd done or lies that he'd told, but not all of them are that nefarious. So one of the lies that the prosecution drew out, he'd asked Paul Napoli to invest $500,000 in his poker matches against Bob Safai. He'd pumped himself up. He's like, I got this. I'm going to win. He sort of really sold himself when he solicited that investment. And then he just lost and lost and lost. But instead of telling Paul Napoli that he lost, he instead claimed that he won and gave him the $500,000 investment back plus some purported winnings. So just out of his own pocket. So that was a lie that the prosecution elicited, but it's a lie that sort of harmed him more than it harmed anybody else. The other thing about the dishonesty is, other than the infidelity, all of this was already in evidence. Jurors had already heard about sort of points at which he'd been dishonest over the last 10 years. So I'm not sure that it was quite as effective as it would have been if it had been sort of the first time they'd heard all of this.
It's often telling when a witness's demeanor changes on cross. Did Goldstein's demeanor change?
He got his back up a little bit, but not in a way that I thought was disproportionate to the questions he was fielding. He maintained his cool. I thought he did generally a good job.
So do you think, all in all, Goldstein helped his case by testifying or hurt his case by testifying?
He did no violence to his case, and it may have helped him. And I really do, actually, on balance, think it did help him, because the jurors needed somebody to fill in the gaps, sort of to explain how all the gambling worked and to explain how they would swap debt. They would, hold on to winnings for somebody else for a while. They would redirect payments from, somebody they'd won from to pay a debt that they owed somebody else. And he was able to say, look, here's where all of the money went. Here's who it belonged to. Here who the investors were. Here's who I paid out. And here's what I took home at the end of the day. And there was really nobody else that was going to be able to do that but him. And the other thing is he brought receipts. He has contemporaneous text messages. For example, the bag of cash, turns out it was a loan, just so he claims. And he's got contemporaneous text messages that reflect that that was one loan he'd received and he was going to receive a second loan. So basically he borrowed like a total of $2 million from one of his former clients and fellow gamblers. He was able to testify about things that they would have otherwise never been able to get in, that I think the jury really needed to hear.
So it seems like the jury will get the case next week.
On Tuesday, the defense has a few more witnesses it intends to call. Among them is the lead case agent in the government's case. That's interesting because, for lots of reasons, but in part because the government did not call this agent in its case in chief.
Holly, you'll have to tell us on Tuesday what the government might have been trying to hide. Thanks for taking us inside the courtroom. That's Bloomberg Law senior reporter Holly Barker. Coming up next, Luigi Mangione has an outburst in court after a state judge set the trial date for one of his two trials. I'm June Grasso, and you're listening to Bloomberg.
Charging with the crime of murder in the first degree and other related charges. How do you plead to this indictment, sir? Guilty or not guilty?
Not guilty.
Luigi Mangione pleaded not guilty to murdering United Healthcare CEO Brian Thompson in December of 2024. The public hasn't heard much else from Mangione until his outburst after a tense hearing setting the date for his state murder trial. As he was led out of the courtroom, Mangione shouted, "It's the same trial twice. 1 + 1 is 2. Double jeopardy by any common sense definition." And state and federal prosecutors have been engaged in a virtual tug-of-war over who will try Mangione first. And even the judges seem to be jockeying for position, with the state judge setting a trial date of June 8th, only after the federal judge set a trial date of September 8th. My guest is former federal prosecutor Robert Mintz, a partner at McCarter English. Bob, the state prosecutors and the federal prosecutors have been fighting over who gets to bring Mangione to trial first. Isn't that something that's usually worked out beforehand by the prosecutors?
Generally, prosecutors do try to work together. And what they do is they look at the federal case and the charges that are brought there. They look at the state case and the charges that are brought there. And they make a decision objectively as to which office has the stronger case and the higher likelihood of conviction. So in many cases, the state charges will have slightly different elements than the federal charges, and the penalties may be different. And so prosecutors will essentially agree which is the strongest case and lead with that. In this case, there seems to be no cooperation between the federal government and the Manhattan DA's office, and there is a virtual tug of war between the two, a battle as to which case is going to be tried first. We even saw at a hearing before the state court judge, the judge make a very unusual comment saying that U.S. prosecutors had essentially reneged on an agreement to let the state trial proceed first. So we're seeing here a very unusual situation where the federal judge has set the trial date for September 8th, which has prompted the state court judge to set a June 8th trial so that the state court case can proceed and be completed before the federal case goes to trial.
Yeah, aren't the judges also jockeying for position a little bit here? The federal judge said that she was proceeding as if the federal case was the only case unless one of the parties raised an issue with her. And the state court judge only sets a trial date when it looks like the federal trial may go first. How do judges usually handle it when there are competing trials?
Well, just like with prosecutors' offices, there is no set process by which state and federal judges must interact with one another in terms of setting trials or anything else. It's just usually a pattern in practice that there is some degree of cooperation and some understanding as to which case should proceed first. Here we saw a case where the state made the arrest first and the first appearance was in state court, but then the case got somewhat bogged down in state court, which has slowed that process. And in fact, there was a hearing in December, an important hearing regarding the exclusion of certain key evidence in the case. State prosecutors had argued that evidence from the backpack that was seized by police when Mr. Mangione was arrested at the McDonald's in Altoona should be admitted into evidence. It includes some key evidence, including a 9mm handgun, a silencer, a loaded gun magazine, and a diary, which, according to state prosecutors, includes some very incriminating statements made by Mr. Mangione, including a comment that Brian Thompson, quote, had it coming. So that's all very critical evidence to prosecutors. There was an extended hearing in December as to whether or not that evidence was going to be admitted into the state trial. The trial judge expects to rule on that decision in May. So the trial judge is taking some time to make what is a very critical decision about what evidence may or may not be admitted in the state court. Interestingly, the very same motion was argued in front of the federal judge, and the judge rather expeditiously ruled that all of that evidence will be admitted, denying the defense's argument that the police improperly searched the bag without a warrant. So that case, in some sense, is teed up and ready to go because that critical decision about what evidence may be admitted to trial has already been decided in federal court. But state court prosecutors are adamant that their case should go first based on the theory that the New York Police Department investigated the crime and federal prosecutors only became involved 2 weeks after the murder. They say that they have a greater stake in the case, and in fact, it's only the state court case in which murder is being charged. It's second-degree murder. The federal charges are stalking charges, which carry a serious penalty because, as a result of the stalking, a death occurred. But the murder charges are only the state court charges, and so state court prosecutors are saying that the case should be tried in state court first, and that federal prosecutors should try the case only after the Manhattan DA's office completes their prosecution.
Mangione had an outburst in court saying this is double jeopardy, trying him twice. And the average person might look at this and say, he's accused of committing one crime, so why are both state and federal prosecutors trying him for that crime? So tell us about the law of double jeopardy and why it just isn't that simple.
Yeah, double jeopardy is a nuanced concept in the law, although it does have a common sense understanding. Basically, the Fifth Amendment precludes a person from being prosecuted twice for the same offense. But there are some exceptions, one of them being separate sovereigns. So, for example, if the federal government and the state government want to prosecute the same defendants for the same act, often that has been permitted. If you go back to the days of the civil rights movement, you may remember instances where a white defendant was tried for the murder of a black person and acquitted in state court, and then we saw federal prosecutors come in and essentially try the case again, alleging civil rights violations violations in federal court and often could get convictions in federal court when state court convictions were not possible due to the makeup of the jury pool. So there is a long history of cases that are substantially similar being tried by different sovereigns, the federal government and the state government. Interestingly, on the federal level, double jeopardy is controlled by a 1932 case called Blockbuster versus United States that basically says that if there are different statutory elements of a crime, then you can be tried in separate cases. So in other words, if in state court you're being tried for murder and there's certain elements to convict somebody for murder, but you're being tried in federal court for violations of someone's civil rights, and there are different elements. In other words, prosecutors have to prove different facts in order to gain a conviction, then those are considered separate crimes and do not violate the double jeopardy clause. In New York State, however, the laws of double jeopardy are actually broader than the protection that the federal Constitution applies. And that's why we're seeing this interesting interplay between the Mangione defense and federal prosecutors saying that they would rather be tried in federal court first, because that will give them at least an argument that the New York State case should be blocked by the double jeopardy clause if the federal case proceeds first.
And explain why the New York double jeopardy law is better for the defense.
The New York State double jeopardy law is broader than the federal Constitution because under federal law, it looks at that blockbuster test, which is only looking at elements of a crime, while the New York State law looks at the second prosecution as the same offense or the same criminal transaction. And so it gives defense lawyers a chance to argue that even though the elements may be different, it's really the same offense and the same criminal transaction. In this case, my opinion is it will be an uphill battle for the Mangione defense team to convince a court that the New York State case is barred by double jeopardy, but there's no question that they will have a better argument if the federal case proceeds first, and then they are in state court arguing that the state prosecution is barred by the prior federal prosecution.
The defense attorney complained about the timing of the trials. Right now, they're 3 months apart if they go off as scheduled. Karen Friedman-Agnifilo told the state court judge, Gregory Caro, the defense will not be ready on June 8th, and Judge Caro said, be ready. Basically having to prepare for 2 trials at once does seem like a lot for one defense team.
Generally, judges are pretty solicitous of defense lawyers who say they need additional time to prepare for a trial, because what the judge does not want to have happen is they go through an entire trial and ultimately there's a conviction, and then on appeal, the higher court looks at the case and decides that the defense was not provided adequate time to prepare for the defense, and the whole case gets thrown out and has to be retried again. So what we're seeing here is that the federal judge set that September 8th date for the federal trial, and the state court judge then counted backwards from that date in order to set a trial beginning on June 8th to allow that trial to be completed first. But as you say, the defense has strenuously argued that they will not be ready by June 8th, and that it is an undue burden for them to have to try the state court case only to then approximately 3 weeks later have to be sitting in federal court ready for another trial. What the defense is arguing is that the defense team is unfairly burdened because they have to prepare for 2 trials while prosecutors only have to prepare for 1 trial each.
Also, Bob, you talked before about how the state court judge hasn't decided yet about whether that critical evidence from the backpack will come in at trial. Judge Caro said he's going to make the decision by May 18th. But they're supposed to go to trial just 3 weeks later. Even though it's unlikely that the judge is going to suppress that critical evidence, shouldn't the defense know that definitively while they're preparing for trial?
You're exactly right. And the federal judge has already heard argument on that very issue and allow that evidence to be admitted. So I think we can expect the state court judge to rule the same way. It would be a devastating blow to prosecutors if the state court judge were to suppress that critical evidence, and it would make it much more difficult for them to gain a conviction. But nonetheless, from the defense standpoint, if you don't know for sure whether that evidence is coming in until the middle of May, and you've got to begin a trial in the beginning of June, it doesn't give you a lot of time to reset your case and to prepare for trial. And that's exactly what they're going to argue. So it's going to be very interesting to see whether these dates hold. One possible issue that could push the dates back is that if federal prosecutors decide to appeal the federal judge's decision to throw out the death penalty charge in the federal case, the state court judge said that he would likewise move back the start of the state court trial.
It wouldn't be the first time or the last that we see delays in trial dates. Thanks so much, Bob. That's Robert Mintz of McCarter English. After widespread criticism of the aggressive tactics by federal immigration agents in Minnesota that left 2 U.S. citizens dead and spurred massive protests, it came as no surprise when White House border czar Tom Homan announced the end of the operation, although he was careful to say that ICE will not be backing down.
If you are here in the country legally, you're not exempt from our immigration laws. If we encounter you, we'll take appropriate enforcement action. For those that say we are backing down from immigration enforcement or the promise of mass deportations, you are simply wrong.
What's been missing in all the criticism of federal immigration operations is a policy that affects every non-citizen detained by ICE, the Trump administration's mandatory detention policy. It's a reversal of every other administration's policy for the last 30 years. The Trump administration is locking up all non-citizens without hearings indefinitely, even if they've lived in this country for decades. And in a huge win for the administration, the ultra-conservative Fifth Circuit Court of Appeals just greenlit that mandatory detention policy. Joining me is Leon Fresco, a partner at Holland Knight. He was the former head of the Office of Immigration Litigation during the Obama administration. Leon, both the Fifth and the Seventh Circuit had arguments on this policy on the same day. The Fifth Circuit made its decision within days. The Seventh Circuit has yet to make a decision. How big a victory is this decision for the Trump administration?
The reason it's a big victory is because most of the detention facilities in the United States are in the Fifth Circuit, Texas, Louisiana, and Mississippi. It's a big part of the detention infrastructure of the United States is actually in those locations. And so what the Fifth Circuit held is that if a person crossed the border illegally and entered the United States illegally, if and when the United States government finally apprehends them, whether it's 2 days later, 10 days later, 1 year later, 20 years later, 40 years later, none of that matters. What matters is that they were apprehended when they had crossed the border illegally. And so under the version of the statute that the Trump administration and the Fifth Circuit feel is the correct interpretation of the statute, they say that no matter when you're apprehended, if you've crossed illegally, your intent is you're trying still every day of your life to be admitted into the United States legally, that this is your goal. Because the statute says if you're seeking admission into the United States, then if you get apprehended, you will be detained indefinitely without bond until we decide whether you win or lose your deportation case. Previously, for the last 30 years, all the administrations prior to this said that at a certain point, after you cross the border, you're no longer seeking admission. You're just here in the country. And that seeking admission is only for people apprehended at or near the border right when they're trying to cross. It's not for people who've been here an extended period of time. Those people are entitled to bond. And so this is a new interpretation that's different than what has occurred in the last 30 years. And so what the Fifth Circuit has said is absolutely, if someone is in detention in the Fifth Circuit and they cross the border illegally, it does not matter how long they've been in the country, they can be detained without bond until they can finally be deported.
And if the Seventh Circuit comes out with a contrary decision, it won't make that much difference because not that many people are held in detention in the territory of the Seventh Circuit?
Correct. What's very interesting about this is usually the government is motivated to go to the Supreme Court whenever it's got bad law. But it would be very interesting if what will have to happen is that the Fifth Circuit petitioners, the foreign nationals, will have to go to the Supreme Court and hope that the Supreme Court takes the case, because usually the Supreme Court only takes these cases for the most part because the Department of Justice is asking them to take the case. Almost always when the Department of Justice wants the Supreme Court to take a case, they take it. But the Department of Justice may say, you know what, if we lose in the Seventh Circuit or the Ninth Circuit, no big deal. We'll just put the visa overstay people in detention in those facilities and they can get a bond and it's not a big deal and whatever. But for the people we want to keep in detention as the border crossers, we will put them in detention in the Fifth Circuit, and that way they won't be able to have a habeas petition. And if the Supreme Court never takes this case, then that can't be fixed.
And I've heard that when immigrants are released while their case is pending, their odds of winning improve.
There's two sort of big dramatic complications when immigration detention is involved. One, to the extent that you have family and friends and everybody else, you're separated from them and you're separated from your source of income, which makes it harder for you to even hire a lawyer in the first place. So you may not have a lawyer because you can't afford a lawyer. That's bad enough. But then it gets even worse, which is even if you have a lawyer, the lawyer now has to communicate with you basically through ICE whenever ICE decides to allow you to be able to communicate with your lawyer. So, you know, most of these detention facilities are in the middle of nowhere. They're not near any lawyers. And so very few lawyers are driving out or flying hours and hours. Usually what you're having to do is set up conferences. So all of that makes it very, very hard. If you're trying to prepare, let's say, an asylum application, you'd be with your client maybe 8 to 16 hours getting their whole story, documenting it, trying to really set forward a case. And you just don't have the ability to do any of that if your client is in detention. So it basically is like saying, fine, we're going to let you play basketball, but you can't use your left arm or your right leg. Good luck to you. See if you can win this match against Shaquille O'Neal or something like that.
Impossible odds there. Leon, federal courts have been flooded with habeas petitions to force bond hearings. According to ProPublica, more than 18,000 habeas petitions have been filed in the first 13 months of Trump's second term. And that's more than were filed in the last 3 administrations combined. Will this Fifth Circuit decision stop that flood?
So if you're in the Fifth Circuit, absolutely, because that becomes binding precedent. So none of those habeas petitions will work in the district courts in Texas, Mississippi, and Louisiana. If you are in other district courts around the country, the problem you have is that Fifth Circuit decision could be cited as persuasive, and maybe the particular district judge who's listening to the case will find it persuasive. And then you'll need to go to the circuit court, and we'll have to see what happens. But the other problem that could happen is the government can try to move you and get your habeas dismissed, and then the court would have to decide whether it wants to keep the habeas or not. So there's just too much uncertainty and procedural machinations that can occur in all of these cases, where at the end of the day, many of these foreign nationals involved, unless they get some very committed pro bono project, are not going to have the resources to make all of these challenges.
It almost sounds like game over.
I mean, the only way that this detention issue will change is if the Supreme Court gets involved and says that the Fifth Circuit got it wrong. But if the Fifth Circuit decision stands, then what you will see is the entire detention infrastructure of America move to the Fifth Circuit, and then that will be how it operates.
And another problem is that attorneys are struggling just to find their immigrant clients who've been detained because they've often been moved to out-of-state facilities and then bounced around. An ACLU lawyer called it a game of whack-a-mole. From the beginning, you can't find your clients. If you find them, you can't access them because there are no phones or visitation rooms. And if you do find them, it takes weeks to contact them. And sometimes they're just moved and deported.
Absolutely. If you are a representative of a person, a foreign national who's in immigration detention, it's the most challenging time it's ever been to do that, in the sense that when you're a criminal, let's say, when you're a criminal and you're in detention, you're usually in detention within some reasonable space from your attorney, and a criminal defense can be planned and a criminal defense can be implemented in a court of law. Here, if you lived in, I don't know, Houston, or you lived in Atlanta, or you lived in New York, you could be detained in Kansas or in Louisiana or something. And then whatever lawyer you would have procured wouldn't have done you any good, because that lawyer is not going to travel to Louisiana or Mississippi or somewhere else in order to be able to reach you. And then even if they did, you might be moved the next day. And so the question of how you actually conduct a defense when you can't speak to a lawyer is very, very complicated. And this is yet another issue that is going to have to come to some resolution, because people are going to start saying that they've had due process violations, and the courts are going to have to decide what is the process that you're due in these situations.
Even when ICE does release detainees, judges are finding that they're releasing them in other states without their papers or phones and with just the clothes on their back. So some judges have been issuing very detailed orders. For example, one Minnesota judge said ICE had to release a detainee, 1 in Minnesota, 2 with all personal documents and belongings such as driver's license, cell phone, 3 without conditions such as ankle monitors or tracking devices, and 4 with all clothing and outerwear he was wearing at the time of detention or other proper winter attire.
And this is not new. This is something I remember from the very first case that I won with a client in detention a long, long time ago. I won't date myself. I remember speaking to a senior lawyer, and I said, what do I do now? And they said, no, when you win a case and your client is in detention, what ICE does is they just open the door of the facility. And so you better go get them, because my client was in the middle of the Everglades. And so they either are going to walk from the middle of the Everglades into civilization, or somebody has to go get them. This is not new. This has always been that way, that all ICE does is open the door of the detention facility and say, okay, walk out of here.
And I thought it was something new. Thanks so much, Leon. That's Leon Fresco of Holland Knight. And that's it for this edition of the Bloomberg Law Show. Remember, you can always get the latest legal news on our Bloomberg Law podcast. You can find them on Apple Podcasts, Spotify, and at www.bloomberg.com/podcast/law. And remember to tune into the Bloomberg Law Show every weeknight at 10 p.m. Wall Street time. I'm June Grasso, and you're listening to Bloomberg.